All right, so by now you've heard about the Don't Say Gay bill in Florida. A bunch of people on Twitter, especially, are melting down. And when aren't they melting down about the idea that Florida legislatures have passed a bill that says, don't you dare say gay in my kid's class? But is that what the bill says? Of course not. Of course, that's not what the bill says. First of all, you would have a lot of trouble passing that bill. Second of all, you would have a whole lot more trouble keeping that bill in relation to recent Supreme Court decisions that have pretty much solidified sexual orientation as protected by the Civil Rights Act and therefore enshrined in the Constitution through the 14th Amendment. And you would not be able to do that. So, with that said, what does this bill say? Why are people so pissed off, and why can't anybody read? That's what we're going to talk about today. I'm Nick Recato of Recato Law, small law firm in central Minnesota. You probably already knew that if you're here watching the video. But if you're new, hey, consider like and subscribe and all that stuff. Okay, we're going to skip that. Here we go. Let's look at the text of this bill, and I'm going to pull up the excerpts that are relevant. It's just two little sentences or paragraphs in the entirety of the bill. Bill is 7 pages, and these are just two brief segments out of those 7 pages. Here's the first one. Very controversial. Prohibiting classroom discussion about sexual orientation or gender identity in certain grade levels or in a specified manner. Now, that's not a sentence. That's just a subsection of a greater sentence that is separated out by a couple of semicolons. And it's important to note that this is in the preamble of the text. So what this is just a general guideline on what the bill is doing. In this particular bill, the way it's written, there is the main section of the bill, which is all in underlined black text. And then there is this non-underlined text, and that's in the preamble. You can see if we go up and down, here's the first page of it. And then we go down into the preamble or through the preamble, and then it goes into here where we get to the operative text being added to the law as it exists. Okay. So it's under Section 8 of student welfare of the bill. They add C1 and it goes from there. So this underlined stuff is the new operative text. All this other stuff before this is just a preamble telling what the general thrust of the bill is. And this bill has to do with parental rights as their children are sent off to a public school where the parental influence or the parental unit is not necessarily as informed about things as they could be. And this is the overall concern. The general thrust of this bill is around targeting physical and mental health care services provided by the school and making sure that parents are on the same page with the school about what services are available to children and about what services are actually being utilized by the children. So in essence, if there's a major physical or mental health change in the child, the parent should be notified about that, which seems pretty reasonable. Now, there are concerns about abuse and certain things being disclosed to parents that would lead to more abuse. One, this is a presumption that is, we'll say, endemic in people discussing these issues. It is a presumption that parents will automatically be abusive to children under certain mental health sort of changes. But two, if there's any indication of of physical abuse or emotional abuse stemming from the home or from these changes, the schools are actually permitted to determine how to handle that without informing the parents. That's still in there. So don't worry if a child comes out as heterosexual in a very bigoted gay parent relationship, and the child comes home and tells their gay moms that they're actually straight, and there's concern about those gay moms beating the children, the school would be able to handle that without telling the giant angry lesbians, right? Like that can be dealt with without fear for the straight student being beaten. Okay, so that's a very important part that's in this bill. It's in the operative text. We're not going to go through all of that operative text. But this also has to do with medications that children may be taking and with certain types of services in regards to counseling that the parent can make, that can say to the school and say, hey, you know what? I'm actually not really comfortable with that being offered to my children. We would handle that type of stuff in our own home. So, but these are the controversial sections here. It's really this prohibiting classroom discussion. But again, this is preamble. This is not operative text of the bill. This is not how the law will read. To go there, we have to go all the way down to subsection 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. Let's tackle the back end of that sentence first because you always want to come at it from the back. Okay, so or in a manner that is not age appropriate. So once we ignore K through 3 from now on, because that is accepted out. So now we're talking about 4th through 12th grade education. If classroom instruction about sexual orientation or gender identity is not in a manner that is age appropriate or developmentally appropriate for students in accordance with state standards, then it's not allowed. And people think that this is vague or something like that, but it's not. Because of that in accordance with state standards line, it simply says, if there are state standards about this, you have to comply with state standards. If there aren't state standards regarding the subject matter, you are in compliance with it. Because if there is no state standard, then you cannot be violating it. This contemplates that there either are state standards on particular subjects or that state standards may be developed and implemented through the normal standard adoption process that the state will go through. So once there is a set state standard, you have to be in accordance with it. This isn't vague at all because, again, if one doesn't exist, has not been adopted by Florida, then you don't have to worry about it. So shut up. All right, now let's get to the other part that's making people mad, though. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3. There you go. Flat out prohibition on classroom instruction. This does not mean incidental discussions. This does not mean bring your parent to work day and two parents show up, one straight and the other straight, and they're male and female. It's not a problem to teach the gay students about male and female relationships through someone just appearing. What is a problem is if you take all of the little gay students and you say, listen, little gay students, the proper family is a mommy and daddy. That would be banned under this bill. You cannot do that. In fact, you cannot talk about sexual orientation or gender identity with those students in a classroom instruction setting at all. That means that the teacher is not allowed to teach about the aberrant behavior of heterosexual relationships. They're not allowed to do it. They're not allowed to teach that some kids might be born straight. They're not allowed to teach that at all. The discussion is out. And if you don't see, I hate explaining the joke, but the obvious joke here is that this is neutral language. It does not say don't say gay. It does not say don't say straight. In fact, it says you're not going to talk about it at all because this is kindergarten through 3rd grade and that's not your role. And the most important thing to remember here is that the state is borrowing the right of education from the people. The state has no inherent right to educate children. The entirety of the public school system comes from the idea that people either individually educated their children or banded together in small communities to create communal schools. And the state is making that process more efficient, more standardized, more well-funded than original. And there's a lot to say about whether or not that's appropriate, but that's the system that we have. But the critical aspect of this is parents have the right, the absolute right to tell the state how to instruct their children because the state is borrowing that from the parents. And more importantly, there is, in my opinion, no such thing as academic freedom in K through 12 education. If you want academic freedom, go teach at a university or a private school. But in public education, there is no academic freedom because you have become an agent of the state, serving at the behest of the parents, appointed through a system that was taken from the power of the parents' right to educate. That's it. You are now part of a state machine that is on borrowed power, which means that the people who you're borrowing power from get to determine how that power is spent, or they can revoke it. But that's why we actually have the sort of democratic process, if you will, of adopting state standards, of implementing education policy, is because the ultimate authority to educate children is and always should be vested in the parent themselves. And just because the parents are accepting the state's offer to take on the role of educating children does not mean that the state gets to then run roughshod over parents' ideas, beliefs, or educational concepts. They don't get to do it. And if you think that the state gets to do that, then you have to abolish things like homeschooling, like private school. And no one should be for that at all. The state is not generally great at anything, and that doesn't magically change with the public school system. And I don't know why everybody thinks it should. But getting back to the root of this, parents have absolute authority over what is taught in schools. And if you don't like it, you either pull your kid out of school or you advocate for change in the school. All right. And that change happens through a government process and either the adoption of state standards or the implementation of legislative acts that become law, like here. So, what is the problem with this, though? Some people out there will say this is vague. I would disagree. Classroom instruction as a term in the Florida statutes about school is used dozens, if not hundreds of times. No one is ambiguous about what classroom instruction is. That is when a teacher is actually instructing students on things in a classroom setting. That's it, when they're instructing. So if you happen to have the scenario where it's bring your parent to work day and two gay dads show up, that is not a problem. That is not a problem. An incidental discussion around that relationship is not a problem. The problem is when you sit down to talk about sexual orientation or gender identity with kindergarten through third grade kids in a classroom setting where you are instructive, where the teacher has authority, where they are utilizing materials to instruct kids. Believe it or not, instructional materials is a defined term in the Florida statutes. And it talks about materials that specifically are determined to aid in the instruction within the classroom. Go figure. I know it's very hard to think about these things. But if a teacher is in an instructional role, they are not to discuss these issues with children. And that is fine because parents don't want them to. The legislature doesn't want them to. And this is facially neutral. Now, of course, there are people who say that gender identity and sexual orientation only apply when we're talking about gay or non-binary or gender fluidity or transgender or something like that. I would call those people short-sighted and incorrect, and so would the law. The law in this case is not ambiguous. Sexual orientation is any discussion of sexual orientation, not just the gays. And gender identity has nothing to do specifically with trans people. It also involves cisnormative gender identities as well, because kindergarten through third graders don't need to know what cisnormative gender is at all from a teacher in a public school. They just don't need to do it. And you don't need to put this on teachers. The real concern we should have is about all of the people so desperate to have agents of the state talking to children about sex from kindergarten through third grade. And this is where the groomer comments have come from that have been a big point of contention in here, and the product of, or the genesis of rather funny discussions on Twitter. But people are asking, why do you need adults to talk to kindergartners through third graders that are not their children about sex? sexual orientation and sexual and gender identity? Why do you need that to happen so badly? And the answer is because there are some teachers out there with an agenda about how they want to instruct children on these issues. And that's not part of the state's curriculum, and that's being laid out here. And if that's only gay teachers, then maybe we need to have a discussion about that. But it would apply the same to if a hetero teacher was going to come out and say, I'm going to teach all these kids about being a straight white male. That's not okay either. And that is also prohibited by the bill. But the real funny part about all of this is if the entire left is saying that if we prevent an agendized discussion about sexual orientation and gender identity, that's going to only affect gay. Are you admitting that there's an agendized approach to this that you're not comfortable with not being implemented at this? I mean, if you want to go there, we could have that discussion too, but anyway, that's what's going on in this bill, and you can find stupid takes all over the internet, but in particular, I will draw you to the ruminations of two individuals, Just Some Guy and Vito, two of the dumbest fucking people to ever discuss this issue. And nothing they can do or say will change that. There you go, guys. There's the text of the bill. There's the thrust of the discussion going on. And at the end of the day, this is about education, not about indoctrination. Education belongs in a classroom. Indoctrination belongs somewhere else, not in a state-funded schoolhouse. So knock it off. Anyway, hope you liked it. Share it, whatever. Catch you soon. Peace. Peace.
So pour out an odd bag about more of that bright. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the love of